Thank you all for joining this Kingsley Napley webinar today. My name is Andreas White and I'm one of the partners in our employment team. And I'm going to talk to you today about the coronavirus job retention scheme and furlough leave. So starting at the beginning. On Friday, the 20th of March, we had a very dramatic press conference with the Chancellor. I'm sure many of you, like me, tuned in live at the end of the week in which we went into full lockdown. The Chancellor announced what he described as unprecedented new measures promising to protect people's jobs. So quoting from his speech, we were told for the first time in history, the government is going to help to pay wages. We were also told that any employer, regardless of size or sector, will be eligible under the scheme. We were told that employers would apply to HMRC for a grant, and those grants will cover 80% of salary, or up to 80% of salary, up to a maximum of £2,500 a month, so 30,000 a year, for employees not working but furloughed and kept on the payroll rather than being laid off. Now, the Chancellor pointed out that, of course, employers can choose, if they wish, to top up salaries, implying, I think, in the spirit of keep calm and carry on, that this is simply a discretionary matter for employers. But that's, of course, a major oversimplification in many cases, depending on your employee's contractual terms and conditions, which will need to be really carefully checked. The scheme is due to cover the cost of wages backdated to March the 1st, and we were told that there would be extension if necessary. I would guess that there is every chance extension will be necessary, but of course that remains to be seen. And we were also told there would be no limit on the amount of funding available under the scheme. Candidly, the Chancellor said that HMRC were working night and day to get it done by the end of April and to pay the first grants within weeks. So that was in less than 6 weeks, and 3 of them have already passed. So I think what we're seeing is a seismic intervention in the labour market with profound implications for employers all up and down the country of every size and shape that's being implemented at really extraordinary, incredible speed, with no time for the normal process of legal reform that involves, of course, consultation, the passing of legislation, an implementation period, and would take months or even years. There's simply no time for that in the current crisis, and so this is all happening at breakneck speed. So what's happened since that dramatic Downing Street press conference? Well, on the 26th of March, we received initial guidance from HMRC. And then on Saturday, the 4th of April, just last Saturday, we received substantially revised guidance was published. So far, we haven't seen any legislation as such. And it's not clear when we can expect to receive this. Parliament is obviously currently on its Easter recess. So that does mean that there is, of course, a high degree of uncertainty. And we have been trying to work out the answers on these things. What we've seen at Kingsley Napley is really incredible levels of interest from clients, alongside huge uncertainty how the furlough scheme is going to work and what the practical and legal implications for employers are going to be. So with so many queries from clients, we produced employer frequently asked questions, FAQs, and we've been regularly updating them as new questions and answers have emerged. We've also published COVID-19 immigration FAQs. And if you haven't already done so, please do check out our latest FAQs on our website, which were published just yesterday. They go into detail which we simply won't have time for today, and they also include links to the government guidance to date. So let's have a look now at some further details of the furlough scheme. And I'm also going to talk briefly about risk management, best practice, and emerging trends when it comes to furlough leave and employment issues in this crisis. And then the idea is that we will wrap up with Q&A, and you'll have the option to send through any questions that you may have, which I will try my best to answer via the Zoom portal. So what does furlough actually mean? And I think it's worth remembering at this point that just 3 weeks ago, the word furlough really didn't exist as far as employment law goes, as far as HR management goes. Now, of course, it seems to be the word on everyone's lips, and we hear it in the newspapers every day. So what it actually means is a temporary leave of absence from work of at least 3 weeks. 3 weeks is the minimum claim period under the Coronavirus Job Retention Scheme, the CJRS, during which time no work can be done for the employer. To apply, you must have been operating a PAYE payroll scheme as of the 28th of February 2020. The scheme only covers staff that were then on your PAYE payroll. But provided they were on the PAYE payroll, then it really doesn't matter what sort of contract they had. They may be full-time, they may be part-time, they may be salaried, flexible hours, even 0 hours, it doesn't matter. What I think we've also seen a lot of questions for so far, and where there is some uncertainty, is how far the principle goes that employees can't work at all during the furlough period. The guidance simply says that work includes providing services and or generating revenue. Presumably, it wouldn't include taking a call from a colleague still working with a work-related question and a need to know. And we're cautiously optimistic that a common sense approach is going to be taken on this point, as we've seen in general in recent days and weeks from government. The aim, after all, shouldn't be to catch good faith employers out on inadvertent technicalities during the crisis, when really that's not in anyone's best interests. Nonetheless, it is clear, particularly from the latest guidance, that the rule is the employee cannot be working at all during the furlough period. And that does seem to be an important principle under the scheme. I would also say that there's bound to be a small minority of rogue employers who do take improper advantage of the scheme. And I'm sure we've all read stories already in the press in recent weeks about fraudsters who've been looking for angles during the current crisis. And of course, that's going to be treated very seriously indeed. So in terms of what you actually need to do, the HMRC guidance states that to be eligible for the subsidy, employers should write to their employee confirming the date from which they've been on furlough and keep a record of this communication for 5 years. So superficially, that sounds incredibly simple. But I think, of course, it's not as simple as that in practice, certainly not in typical cases that we're seeing. And I'll come back to that in a moment. What is also clear is that all the signs are that there will be no need to prove as employer that you're suffering financial losses, that it's a situation of closure of your business or premises, or indeed any other type of redundancy situation. Of course, the classic definition of redundancy is reduced requirement for employees to carry out work of a particular kind, but that's not what this is all about. The guidance does refer to employers whose operations have been severely affected by coronavirus. But it then goes on to say that the government recognise that different businesses will face different impacts from coronavirus. And I'm sure we've all found already that all our businesses have been affected one way or another. Some of us can muddle along as best we can, working from home. Other people simply can't work at all. Other people may find that clients and customer demand has fallen off a cliff during the crisis. So it really does vary from case to case. And it seems that the government essentially recognises that it's not going to be necessary to try to prove some sort of particular impact on your business in order to access this scheme. Frankly, everyone is affected one way or another. Really, their position seems to be that unless all your people have got work to do, and if you're actually hiring, so for example, the major supermarkets are in that position, then in principle, the option of furlough leave with publicly funded subsidised wages could be open to you. And I think that illustrates a pragmatic needs must approach from government, which has to be welcomed. So I wanted to talk a little bit about joiners since the 28th of February and also leavers since the 28th of February. If we cover the question of new joiners first of all, it is clear, and this is something again where we've seen numerous queries, that new joiners since the 28th of February are ineligible under the scheme, and it would not be possible to make a successful application for a grant to cover their wages, even if in fact the nature of your business is such that there is now no work for them to do. And that has been causing quite a lot of concern and trouble in practice. And there is a real concern that new employees who've joined their new organisations since the 28th of February could be left high and dry. So you may ask, well, why does it matter if someone has joined after the 28th of February? The reason is that the government say this is a fraud prevention measure, and that the only way they can verify that an employer has not fraudulently put people on the payroll in order to make claims under the scheme is to check that they were indeed on the PAYE payroll on 28th of February, which is of course the last day before the subsidised wages are potentially available from the 1st of March. That did leave a lot of concern that people could be left high and dry, etc. And certainly I myself have noticed lots of queries as to people's new job offers falling through, job offers being withdrawn. So that focused attention on people who had left since the 28th of February and leavers. And what we've discovered during the process of the guidance so far is that it's possible, and it's even being strongly encouraged, certainly by government and by certain consumer rights champions and so on and so forth. It's possible to renew fixed-term contracts that would otherwise have expired during the furlough period, at least for the furlough period itself. And it's also possible to make claims on behalf of employees who were already made redundant at the start of this crisis in the first half of March. And indeed, that even applies to people who terminated for any other reason since the 28th of February. It now doesn't matter under the latest guidance why they left. What does matter is whether the employer is willing to re-engage and re-employ the individual, take them back in order then to make a claim under the scheme and to get the subsidised wages grant from the government, which is then of course passed on to the individual. And that's the whole idea of the scheme, to keep people in an income. I think it remains to be seen how far that is actually going to work in practice. It's certainly a novel idea, which I think needs to be quite carefully considered. The decision to re-employ is certainly a discretionary decision for the employer, just like any decision to make an application for a furlough grant itself and put someone on furlough leave. It is an employer discretionary decision. Some employers will only be able to offer re-employment as a temporary measure, and the CJRS wage subsidy remains available for that temporary period, so they may want to re-engage for that time. That seems to be permissible. Others will structure this re-employment idea with a short break in service, although whether that's going to break continuity of service for the 2-year unfair dismissal qualification period remains to be seen. In any event, the purpose of this innovation is obviously laudable, but I'm doubtful how effective it's going to be in practice. Although again, having said that, I have seen it being applied already in some cases. I should also say that there is one potential exception to the idea that new joiners since the 28th of February are not eligible in any scenario. And that's the case of employees who TUPE transfer in after that date, where all the other qualifying conditions are met. Again, with the purpose of this scheme in mind, it wouldn't make logical sense if a TUPE transfer change of employer prevented the application of the CJRS. And we've seen informal confirmation that to be transferred employees remain eligible from the Treasury, which is very welcome. I do hope that this potential loophole will be firmly closed as and when the legislation is published. Looking then at part-timers, looking at second jobs, in what I think was also a very interesting development, the government has clarified that if an employee has more than one PAYE job, then each job is treated separately. So the employee could, for example, be furloughed in one job, but continue working in their other job. They could also actually be furloughed in both jobs. And the financial cap on the claims, so to recap, the maximum payable under the scheme is £2,500 per month gross. That's the maximum that can be claimed by the employer, although they can also claim employer NICs and 3% auto-enrollment pension contributions. The maximum amount is going to apply in relation to each job. So if you had an employee who actually had two highly paid part-time jobs, potentially they could actually be getting more than £2,500 a month under the scheme. Probably that's going to be quite rare, but it's possible. It's also clear that an employee can start a new second job whilst they're on furlough leave. That's not prohibited by the scheme itself. After all, the government wants to encourage economic activity as far as it can still occur during the current crisis. That does, however, raise a question as to what the employee's current contract says. Many contracts, executive contracts, certainly would typically provide a kind of no moonlighting clause and would provide that you can't work in any other capacity for any other employer, at least not without prior employer consent. But there's nothing wrong under the scheme with the idea of an employee taking up a second job or some other kind of work during the furlough period. That's absolutely fine. Likewise, unsurprisingly, voluntary work is being strongly encouraged, and that's something that employees may want to do during the furlough period, and indeed some employers are, of course, actually actively facilitating that. That's a very good thing, no problem at all. And the government have also said that training during furlough leave, so online training, a bit like this session now, is welcome and to be encouraged. And going back to the point that I've already emphasized several times as to the principle that employee must not work for employer at all during the furlough period, the training exception is the only concrete exception that we've seen so far during the process of guidance as we've gone through this process. I was briefly going to mention sponsored migrants and the new Home Office guidance, which I think was published last Friday. In the early phases of this debate, there were various initial uncertainties as to how, if at all, furlough leave could apply to sponsored migrants. The reason for that was that sponsored migrants have minimum salary levels that apply to them depending on their visa category, but also depending on the particular occupation that they're engaged in. If they are only going to be receiving the subsidized amount of pay under the scheme during furlough leave, that would be below the minimum salary levels that are mandated under the immigration rules. So that was causing quite a bit of concern. We also saw other concerns from clients around where sponsored migrants would stand in this process. There were questions around working from home. There were questions around unpaid leave. Happily, those issues seem to have been ironed out. The Home Office guidance, as I said, came out, I think, last Friday. You'll find a link to it in our immigration FAQs. And it does seem that that issue has now kind of died down. There does, however, remain legal uncertainty on the interaction between annual leave and furlough leave. So I think it's perhaps worth remembering at this point that we've seen lots and lots and lots of holiday pay litigation in recent years, lots and lots of test cases, looking at how far annual leave works when it comes to people who are absent for some other reason. So we've had the sick pay cases. We've also obviously had maternity leave cases. And we know from those cases that annual leave cannot coexist with, for example, maternity leave. If you're on maternity leave, you're not on annual leave. You can't use your annual leave entitlement during maternity leave, and indeed you continue to accrue your annual leave entitlement. Likewise, you can't use your annual leave entitlement whilst you're on sick leave. But I do think that furlough leave is different to, for example, sick leave. It is a period of rest. Of course, we can't take a proper holiday at this time, and we can't even leave our houses. But it is, unless you're in one of those people who are working from home, if you're furloughed and you're not working, then it does seem to me to be a period of rest and to meet the kind of health and safety requirement that's built into the EU law right to annual leave. So we do think it is possible to use up some of the annual leave during a period of furlough leave. We do think it's certainly possible for employers to require their employees to use a proportion of their annual leave entitlement during the furlough leave. I think it's sensible to limit that to the proportion that actually accrues during the furlough leave. So if it's a 3-month period, then that would be 3/12 of the total annual entitlement. And of course, going back to all the holiday pay litigation, it's always advisable to pay normal remuneration in full for annual leave. And I think employers who try to limit it to the amount that they're reclaiming from the government could find themselves on shaky ground there. So I hope that I've given you a better idea now how furlough leave works, how the grants will work in practice. And I also hope that I've encouraged you to think seriously, if you've not already been doing so, whether this scheme could help your business and people during the current crisis. At the same time, I don't want to make it sound like this is easy or it's straightforward. Of course it's not. We do think there's real risk and scope for a backlash in this situation. Certainly, some employers, it appears, have taken away the wrong message from the government guidance to date and may have believed wrongly that the guidance and the new scheme from the government has essentially given them a free rein to impose pay cuts. And all the usual rules would apply. You know, you can't act in an arbitrary way. You mustn't act in a high-handed way. You mustn't act in breach of contract. So we do think that good communication and fair process are as important now as ever, maybe more important now than ever. And I think that applies not only if there's no way of avoiding redundancies and or pay cuts, but also on tricky questions around the needs of the business and who should and who shouldn't be put on furlough leave. Again, whilst the legislation is awaited, there's absolutely no suggestion that the normal legal requirements to adopt a fair process of consultation and to seek employee agreement no longer apply or should be disregarded. Yes, you may need to do things in a more accelerated way than usual. And of course, this is a crisis. So I think that will be recognised, but it doesn't mean that the process can simply be disregarded altogether. Indeed, the government guidance expressly notes that employers should discuss with their staff and make any changes to the employment contract. And that obviously includes any temporary pay cuts. I think we can be very clear about that. That should occur by agreement. So we think it's going to be as important as ever for employers to be able to show that they acted fairly and reasonably if they find themselves in dispute with employees and facing potential employment tribunal claims. We even think that the introduction of the furlough scheme, the CJRS, could mean that employers are going to be held to a higher standard in this crisis than would otherwise have been the case. If, for example, they rush through redundancies without proper consultation when they could have taken their time, consulted and sought to use the furlough scheme to avoid, or at the very least to delay, redundancies, knowing full well that the HMRC subsidy for wages is currently available. We do think it will potentially be fair for unfair dismissal purposes to dismiss employees who unreasonably refuse to agree a pay cut, provided the consultation process is fair, particularly if you offer to re-engage dismissed employees on the temporarily reduced wages that are available under the scheme. Of course, every case is going to turn on its own facts, and it's going to depend on the circumstances. It's hard to generalize, and I do think we can say for sure as to what we've seen so far that there really is no sort of one size fits all approach to these difficult issues during the current crisis. There's no easy answer to this to these issues. I should also say that collective consultation obligations may apply depending on the circumstances. That's the case where 20 or more terminations, including under varied terms of employment, could apply in 90 days or less at any one establishment. Collective consultation outside of the largest employers, outside of unionized workforces, doesn't seem to have been a large feature of what's been happening so far in practice on the ground that we've seen, but it does need to be borne in mind. You need to think about it depending on the circumstances of your case. As a reminder, there's extensive commentary on these issues in our employer FAQs, looking at the process, looking at what you need to cover in your furlough letter agreement. I can't really begin to do justice to all of that now because of time constraints. So please do check out the FAQs. In conclusion, before we come on to Q&A, please do send through your questions through the portal. I would repeat what I've already said, that government themselves seem to be taking a pragmatic, flexible approach to this whole issue, bearing in mind the scale of the crisis and what we're dealing with and what they're trying to achieve: protection of jobs, protection of wages. I also think we've seen encouraging trends in terms of employees themselves taking a realistic approach, given the scale of the crisis, the obvious effects on business, and, let's face it, the risks of redundancy if people aren't willing to compromise. And what we're seeing amongst clients, I think, on the employer side is really every effort to preserve normal earnings as far as possible. Employers are working on morale. They want to protect their business. They want to protect their people. So I think they're making every reasonable effort to preserve normal earnings as far as possible. Of course, in some cases, it is necessary to deal with the pay cut issue under the furlough scheme. But I think in many cases that we're seeing, actually, that's not necessarily the approach that's being taken. Employers are choosing to top up. But of course, we're also seeing people apply a kind of package of measures to try and deal with all of this in the round. Well-publicized cases that are being reported in the news. There's talk about people agreeing to do, for example, a 4-day week from home in return, say, for 80% pay. It does make a big difference if you're in a job where it can be done up to a point from home, as opposed to a job that simply cannot be done from home. But shorter hours and shorter pay is, of course, another solution that's being used often alongside furlough. Voluntary sabbaticals is also being used. And I think that employers are trying to manage the process and manage the message as carefully as they possibly can, just like the government. The message really is, we're all in this together. So again, what we're seeing is dividends being cancelled. We're seeing examples of senior management teams also taking a pay cut. There are reports of board level bonuses being donated to charity, that sort of thing. And I think where the message is we're all in it together, then that really does increase the chance of reaching sensible agreement with employees on the furlough side and any necessary pay cut whilst the scheme remains live. Okay, so that's been a pretty quick canter through the basics of the scheme. I haven't dealt with everything, but we are planning to do some Q&A. So let me have a look as to questions under the portal. So there's a question as to employees volunteering their time. I don't think the question asks if the employee can volunteer their time to help the business. I don't think that's permissible if they're helping their employer. Because after all, the way the scheme works is the government, HMRC, will subsidise wages and then they're paid to the employee. So the government guidance is clear that the employee cannot be providing services and or generating revenue during the period of furlough. But as I mentioned earlier, of course, volunteering in the voluntary sector is strongly encouraged, and we know that there's been a huge response to the request for NHS voluntary help at the moment. So then we have a question relating to the eligibility of Tier 2 sponsors with sponsored migrants to furlough their Tier 2 employees. So I did talk a little bit about that. The person asking the question asks, well, the Home Office guidance says that it must be a company-wide policy. The Home Office guidance from memory talks about how sponsored migrants can be put onto the furlough scheme, provided that they're treated the same as everyone else and it is a company-wide policy. But our reading of that is that it simply means that you're not making a distinction as to whether someone is or isn't a sponsored migrant. It doesn't mean that the whole workforce then has to go on furlough leave. That wouldn't make any sense. That particular question is actually addressed in our current immigration FAQs, so please do have a look at those on our website. There's also a question about rehiring an employee, which I do think is a very interesting issue. To clarify, could we rehire an employee with a week gap between their last date and when we reinstate them? However, even with this gap, their continuous employment may still stand and therefore may be protected by their 2-year service for statutory purposes, unfair dismissal, statutory redundancy pay calculation, etc. So yes, I think that is a sensible idea, to structure it with a short gap if you feel that you need, from a risk management perspective, to just try to cover yourself on that point. There are rules, there are quite complicated statutory rules around situations in which, even though the employment contract wasn't live for a period, nonetheless it's treated as if it was, and the continuity of service is preserved. I think if the employment really terminated and there was a period when there simply was no employment contract and no current expectation then that it was going to be revived, then potentially it is a proper gap for continuity purposes. But that would need to be looked at, I think, more carefully on a case-by-case basis. So there's another question about re-employing people, which, as I said, certainly is raising a lot of questions. Again, we have covered that a little bit in our FAQs. The question is around, well, what happens to severance payments, redundancy payments already made? They may have to be repaid. I would imagine the way it worked through the payroll, when you discuss it with your payroll provider or your finance team, would be that actually then there would be some sort of offsetting, so that when you recover the grant from HMRC, instead of paying it to the employee, it would have to be then managed through in terms of the payments already made to them. But I'm not a payroll expert. So we have a question about 2P as well, which, as I said, is a really interesting situation at the moment. So the question is, if the transferor's holiday year is April to March, is it acceptable for them to transfer a holiday balance, the average outstanding balance of 6 days per employee, this is in an outsourcing situation, whilst using the furlough period as an excuse to transfer this balance? I fear that the answer to that question is yes, that is acceptable. I think it raises broader issues around the way in which things work between transferor and transferee in 2P transfer situations in outsourcings, which is obviously a controversial topic when you have a change of outsourced provider. And so the transferor really has no commercial reason to be cooperative with the transferee, even though, of course, the 2P regulations do require information now to move across from the former service provider to the new outsourced service provider. But I think employees will transfer across. Of course, they will transfer across with their outstanding annual leave entitlement around in full. And we do think that annual leave continues to accrue during the furlough leave period. As I also said, I think potentially annual leave can be used during furlough, and that it is possible for an employer to actually manage it in that way, but I don't think it's mandatory. And probably in the situation we're talking about, there would simply be no commercial reason for a transferor to do that. So then there's a question about online training. The question is, if we offer online training to furloughed employees, do we pay them their normal rate of pay, or is it acceptable to pay them not more than the furlough payment under the furlough agreement for that time? So good question. That has also been dealt with in the latest HMRC guidance. So what HMRC are saying is that you may have cases of lower paid employees who during the furlough leave period will actually be earning, with reference to what their normal hours would have been, less than the national living wage, the national minimum wage. That would apply also, for example, to apprentices. And there is quite a bit of guidance on that, which again, I couldn't get into today. So the idea is, what HMRC have said is that during such hours as are spent carrying out training on behalf of the employer, where the employer has asked the individual to do that, directed them to do that, or it's part of their training program, then they must be paid at least the national living wage or the applicable national minimum wage, apprentice rate or whatever, for the hours spent training. So you'll need to keep a record as to what those hours were during the furlough period. But otherwise, there's no particular rule that says you must simply pay in full for those hours. That, I think, is a question of agreement in terms of how you agree things under the furlough agreement with your employees. Many employers, as I've said, are offering some degree of top-up, full top-up, or at least some degree of top-up of normal wages during furlough leave. But if in your situation you are able to agree the temporary pay cut and the person will only be earning the subsidised wages available from HMRC during the furlough period, then in principle, that would be all they would get for the training hours as well, provided it doesn't take them below the applicable national minimum wage. So then there's a question about what evidence do employers need to demonstrate how they select employees for furlough. So there is, again, some commentary on that question in our employer FAQs. Initially, we thought that in terms of selecting who to put on furlough and who to keep behind for essential work, employers would be well advised to sort of follow a kind of quasi-redundancy program, and certainly to have some kind of paper trail that evidences why decisions have been made. There is an area of sensitivity, which again I haven't had time to cover today, which is around the application of the Equality Act and discrimination rights, and plainly those decisions must not be discriminatory. And we think that there are also going to be scope for disabled employees, the most vulnerable employees who have to be involved in what's called shielding and be completely cut off from the outside world for this 12-week period. Those employees could claim that being put on furlough was actually a reasonable adjustment, given many of them will be disabled for Equality Act purposes. But going back to the question of evidence, I don't think there isn't anything in the guidance as such on that, and I think it's all the usual things about employment law and HR best practice, and you need to have a reasoned business case for why you make your decisions and be ready. I think we've seen this a lot already. You've got to be ready to explain that to the workforce and to affected employees, because the communication side is really important. I think if people understand why decisions are being made, then there's much less chance of them challenging it. But there's nothing in the guidance as such. But of course, it's always a good idea to have some paper trail showing, that you've applied objective business analysis and decided how and why people will go on furlough or won't go on furlough. So we have a question about a high earner refusing to accept a furlough proposal. The business is not in a position to top up the salary. What could next steps be using a fair process? There is obviously a huge gap between the amount that is available under the scheme, which, as I said, on an annual basis is essentially 30 grand for employees, and what a lot of higher paid financial services, professional services, or whatever executive employees are going to be earning. Larger firms, larger businesses, I think, are looking at top up and other solutions. But in the more kind of startup environment and in smaller, more vulnerable businesses, that is just not going to be realistic. So if your employee is unwilling to agree a reasonable pay cut that really is necessary at the moment, and I don't necessarily, when I say necessary, I'm not saying that you have to prove it's necessary, and I'm also not saying that you have to be sort of teetering on the brink of insolvency before you can do this. You're entitled to make prudent decisions to manage your cash flow and to protect the business, during this period of great uncertainty. So I think, provided you consult, that always involves communication. Normally, it would involve ideally face-to-face meetings, but at the moment, Skype or Zoom or whatever is the way to do that. But I would have a process of meetings. I think it can be done relatively quickly, but certainly take, say, at least a working week over it. Have at least 2 discussions. maintain some notes of those conversations, what you've explained, what the employee's position is. If they simply will not agree, then it goes back to what I said during the talk, which is that we do think it will be potentially fair to dismiss as redundant employees who unreasonably refuse to take a pay cut. And then, you would need to follow a normal redundancy process in going through that, but you would have already started the consultation process. It's not a case, as I see it, then of kind of selection for redundancy and that sort of thing. And provided if you're a small business and there are less than 20 employees at risk in any 90-day period, then you're not in collective consultation territory either, which is of course, more complicated, involves offering the opportunity to elect employee reps, etc. There's a question about a member of staff, part-time, self-employed, not on PAYE. What happens to them? Well, the answer quite simply is they are not eligible under the coronavirus job retention scheme. The gateway is that someone is a PAYE member of staff as of the 28th of February. That is absolutely clear. The self-employed, of course, have provision under a separate scheme, the self-employed income scheme. That for someone, for lower paid self-employed people, you mentioned this is someone who is part-time and self-employed, then actually that scheme does look quite flexible and potentially generous. It's going to take time for those grants to become available, but I don't think you can get involved in that because you don't want to undercut across the principle that this is a self-employed person. It will be a matter between them and HMRC. And I think, again, under that scheme, a lot depends on the tax returns that have previously been filed by the individual under self-assessment. So there's also a question around the interaction between sickness absence and furlough leave, which is also a live question. That is quite a topical question at the moment that we've seen quite a bit. Again, that is addressed in our employer FAQs on the website. What the government say, what the HMRC guidance says, and this is logical, is that when someone is on sickness absence and in receipt of statutory sick pay, which is of course also administered through HMRC, then they can't also be on furlough leave. And the idea is that if you have a period of absence of a week or two, or even a period of self-isolation because someone has to self-isolate because a member of their household has shown, symptoms, persistent cough, etc. The idea is that period of sickness absence needs to be treated separately. When it ends, then the furlough provisions apply. And of course, you may well have provisions in place around contractual sick pay rights that apply to your employees, so they may get more than SSP. But certainly what is clear is that SSP, statutory sick pay, cannot coexist with furlough leave and pay. One question, do we have to send a formal letter to furlough staff or is an email sufficient? So I think that raises two questions. The first question is, can you just communicate via email? And I think the answer to that must be yes, because after all, it's 2020 and we're in a crisis where obviously sending things by post is a lot more difficult than usual, and that doesn't necessarily even make sense. So we do think that email communication is fine. We also think that in a lot of cases, in typical cases where there is complexity involved and where the nature of the furlough letter that you send to your employee, even if it's couched in fairly directional terms, we've been involved in discussions and consultation. As you know, we've been communicating, this is now what we're proposing to do. And then it sets out the nature of the furlough terms and how it will work. We think it's a good idea at the end to have a paragraph at the bottom where it says, I accept these terms, and the employee signs and returns it. So for that, you do really need a letter, although of course you can kind of build that language into an email as well, but it probably works rather better with a letter on letterhead if that's practical for you. There's a question about bank holidays. As I've already said, I do think that furlough leave can potentially coexist with annual leave. I don't think taking annual leave during the furlough period breaks the furlough period in the way that might apply in other situations. And I think it is a good idea, as I said in the talk, to pay normal remuneration in full for any annual leave, either the employee voluntarily takes during the furlough period, or indeed that they take because you direct them to do so as employer with double the notice that's required under the working time regs provisions. So you could say as employer, well, employees were not able to take a holiday on the bank holiday days. Bank holidays are part of their contractual entitlement, and that is, of course, very typically the case, certainly with kind of executive and white collar type employment contracts. So you could then say, well, that entitlement is carried over, but I don't think people want to have large amounts of holiday being carried over just to be used then when business actually does get back to normal. We all then want to go back to work. So I think it is fine to say those days are taken as holiday, but I do think it's advisable, as I've already said a few times, to pay normal remuneration for any days that are holiday taken from the annual leave entitlement, because the line of cases from the European Court of Justice on the principle that during working time regulations, working time directive, annual leave, the employee must receive their normal remuneration as if they had been at work. It's such a strong line of authority, and the European Court of Justice has tended to be really, really strong about policing that principle. So I do think it's a good idea for annual leave during furlough leave to be paid in full as usual, not to be only subsidised by the government at 80%. So then there's a question about garden leave. If an employee was made redundant on 15th of March on garden leave until 15th of April, if we decide to furlough, when would the furlough period begin? Well, the furlough period begins as of the date when the employee stopped work altogether. Garden leave, of course, is a period of time when you're still in employment, but you are not working, you're not permitted to come into work, you're not supposed to contact clients, business contacts, etc. So garden leave certainly is compatible with the idea of it being furlough leave. And remember that when you write to an employee to confirm that they're on furlough, you can backdate the date from which they are to be on furlough leave for the purposes of your application to the government for a subsidised grant. As I've also said during the talk, there is no prohibition on including leavers in the furlough grant scheme. So I think the answer to your question is that it's the dates they went on garden leave, which is the 15th of March. I think you've also potentially got a dilemma on your hands, and it frankly is a bit of a tricky dilemma. Some employees are raising this point, some are not, but you do potentially have a dilemma on your hands as to whether to say, actually, we're now going to extend the period of employment up to the 31st of May. Because in many cases, the employee would have been going to join a new job, and now that job is no longer there for them. And in those cases, I do think you need to really seriously consider whether you can extend the employment at least until the 31st of May, or whenever the CJRS is brought to an end, if and when it's extended. And we've seen that happening in practice. What about employees on maternity leave? The government guidance says that, of course, the normal rights and entitlements of employees on maternity leave, or indeed on any other type of family-friendly leave, so adoption leave, shared parental leave, for example, the normal rights and entitlements of those employees continue as usual, and we know that they are sacrosanct in kind of law from an EU law perspective. The government has, however, said, and I think this is perhaps surprising, but it illustrates the fact that this is a subsidy scheme that allows grants to be paid to employers to help them and to help their people. The government has also said that if you have contractual earnings related enhanced maternity pay payable during a period of furlough leave, then you can actually reclaim that. So unless I have missed something on this, it looks like a bit of a no-brainer that if you've got employees who are on maternity leave or on shared parental leave, for example, and if they're entitled to enhancement above basic statutory maternity pay, then you might as well deem that to be a period of furlough and claim it back from HMRC. That seems to be expressly allowed under the rules that they've published. On the other side of the coin, there is also talk that some employees on family-friendly leave may actually have an incentive to bring their maternity leave or their shared parental leave or whatever to an early end in order to come back and then to go on furlough leave instead. As I said earlier in the talk, certainly maternity leave can't kind of coexist with another leave as such, even though there is this kind of anomaly around reclaiming earnings-related enhanced maternity pay. But otherwise, I think essentially maternity leave and pay carries on as usual. The statutory side carries on as usual. If you were going to make a claim for earnings-related enhanced maternity pay from HMRC, then the normal rules would apply about having to write to that employee to say, as of this date, it's you're deemed to have been on furlough leave, but the employee will not be working. So that that gateway seems to be met. The 28th of February PAYE gateway date should also be met. There's a question about what can training include. I mean, I think the only thing the government guidance says, it expressly refers to online training, and obviously the chance of actually doing any kind of training at the moment that's not online is minimal. It's not realistic. So, but online training obviously these days is booming, and there's an awful lot of that around. So the government seems to be encouraging it, and I think that's a really good thing. Another question: am I right in assuming that the furlough system allows for only part of the staff to be furloughed? In that case, have we got freedom to select whom we put on furlough, or are there guidelines or things we need to avoid? So 2 questions there. Is it right that the furlough scheme only allows for part of staff to be furloughed? No, it's not right. Potentially the whole of your staff could be furloughed. And that's obviously going to apply typically in the case of businesses who have just simply had to shut their doors altogether during the crisis. Pubs, restaurants, leisure centres, gyms, etc. So potentially the whole workforce could be furloughed. There are even provisions in the new guidance, which again I didn't mention today, around the possibility of company directors being furloughed, which I think are a bit surprising as well, but that seems in principle potentially to be available. In some cases it does raise some issues. That's covered in our FAQs. But the idea is that the whole staff could be furloughed. Only one member of staff could be furloughed, or any number of variations in between. It's about whether they are doing any work. And if they're not doing any work because the business is shut, the premises are shut, or simply it's just not business as usual, that kind of work doesn't exist, then they can be furloughed. And in answer to your question, have we got the freedom to select whom we put on furlough? Then the answer is yes, it is a discretionary decision to be made by the employer. Of course, when it comes to discretionary employer decisions, you need to ensure that you've acted, I was going to say reasonably, but certainly the test is more around not acting arbitrarily. And we talked about wanting to have, a paper trail to show some sort of evidence as to how you addressed those questions and decided who to put on furlough. But it's very much a discretionary decision for employers. Can you pay furlough to someone who has moved out of the UK for this period to be with family abroad? Yes, I think you can. The other conditions need to be met. They must have been on the payroll as of 28th of February, and they must have stopped work altogether. If they're working from home, their home being abroad, their family home abroad or whatever, then they don't qualify. But if they are not working, then that's fine. And it doesn't matter whether they're, sitting in their home in the UK or they've gone back to their family home abroad. Is it reasonable to get furloughed employees to dial into employers' daily update calls without requiring them to do any work for the company, just to keep them involved in what's going on with the business? We really don't know where the line is drawn at the moment as to what constitutes not doing any work at all. And as I said earlier, the government is being pragmatic so far and flexible as to how this would work. We think HMRC will do the same. It's not in anyone's best interest for a sort of overly technical approach that's taken. There's no reason to try to catch people out. But if it's literally every single day, I've got to say that that probably seems potentially excessive, and I think that is more likely to raise questions than the example I gave in my talk around, there is a need to know situation where you need to contact a furloughed employee to ask them a work-related question. There's a lot more that I could have said around, what it means not to work at all, and we've had questions, for example, around ongoing disciplinary and grievance procedures. There really isn't any sort of guidance on this at the moment, and we, obviously there's no case law that applies. We don't even have any legislation. So I think, in principle, the idea of keeping people informed is a good one, and I don't think that ought to be a problem. But perhaps requiring them to dial into daily updates could be excessive, depending on the circumstances. Another question: is there a restriction on making redundancies to those who have been furloughed after they return? No, there is not, and unfortunately, that is going to happen. This is where I think there is potentially a problem, is making redundancies in the meantime. It's not prohibited as such, but as I said in the talk, we do think that there's then going to be a big question arising as to whether the employer did all they could to avoid the redundancy as would generally be required from an unfair dismissal point of view, And if the employment could be continued for the furlough period, and if the government, wages can be claimed and paid back to the employee, then arguably there shouldn't be any redundancy in the meantime. But certainly not, there is no prohibition on redundancies after furlough. Now a question about startup founders, which is something we also see a lot in the firm. What would your advice be to startup founders who may have been paying themselves a small salary and topping up by way of dividend? Obviously, that's very common in practice. The answer, put simply, is that you cannot reclaim in relation to dividends. Only PAYE earnings are eligible under the guidance as to what can be claimed back, the 80% of what can be claimed back, but it is restricted to PAYE earnings. So we certainly are seeing a lot of cases where entrepreneurs and people, with personal service companies, that sort of thing, are finding themselves in a difficult position there, because it seems that the dividend amount is also not covered under any other relevant scheme that applies. So, you could be looking at a very minimal amount of 80%. The 80% is potentially available, but the company director must be on furlough. Now, it's worth having a look at the HMRC guidance on this, and it is covered briefly in our FAQs. The government has said that it wouldn't be a problem during furlough for direct to continue to do such tasks as reasonably necessary to comply with their statutory duties to the company under the Companies Act. But they can't be working. They can't be working as usual. They can't be generating revenue. They can't be generating leads. I think that's going to be pretty difficult for most startup founders. And if your startup is a chain of boutique coffee shops, then maybe there really just is no work to be done at the moment, and it's possible. But for most startup founders, I think that they're going to want to continue working in large parts as best they can from home, and that is not compatible with the scheme. There's a question around pension. Are furloughed employees eligible for benefits including pension? The answer to that is yes, contractual rights continue, and actually the 3% employer auto enrollment contribution can be reclaimed under the furlough scheme itself. My last question talks about what you provide for in your furlough letter agreement about ending the furlough period if you're the employer. And I think the answer to that is that you need to have some sort of provision in your furlough letter that says, and we can bring this to an end very quickly with short notice. I think that notice can potentially be as short as 1 day. And I think you're also entitled to provide that furloughed employees need and must remain contactable during the furlough period. We don't know when business is going to come back and we can return to work, but as soon as we can, it's going to be important to do so straight away, obviously. So I think that's the way to deal with that. Thank you so much for tuning in. I hope it's been useful. I hope that everyone is kind of staying safe, staying well, doing the best they can. And we hope to see as many of you as possible soon in person, when hopefully we get back to work and we can resume doing our normal breakfast meetings and seminars in the office instead of this rather strange Zoom environment. Okay, thank you very much.